All right, welcome back, everybody. We had a really great question. One of you came up and asked Justice Simonis about this, is I have experience with judges being rude, disrespectful towards female attorneys in the courtroom, and some suggestions on that. And so Justice Simonis' suggestion is, if you've got an ally on the bench in the judiciary, go and talk with them and raise the issue. You know, you cannot remain silent on these issues. Go and talk with, another judge that you know, somebody who works in the AOC, reported to the Judicial Conduct Commission. He says, but you cannot allow that to happen. So we appreciate that question. We are pleased and excited to have Professor Shima Baughman here with us. Is going to talk about a study that she's been working on since 2015, Race and Class, a randomized study with prosecutors, and I think I got the title a little bit wrong. But let me introduce Professor Baughman for those of you that don't know her. She is the Associate Dean of Research and Faculty Development at the S.J. Quinney College of Law. She's also a professor there. She received her Juris Doctorate degree from BYU, graduating summa cum laude, and she went on to become a Fulbright Scholar in the Pretrial Detention U.S. Department of State. Her teachings and scholarship focus on criminal law and criminal procedure. She is a national expert on bail and pretrial prediction, and her current scholarship examines criminal justice policy, prosecutors, drugs, search and seizure, international law, terrorism, race, and violent crime. Professor Baughman has worked with economists and political scientists to write articles involving advanced empirical modeling and randomized controlled trials, including the largest global field experiment in the world. Her work has been featured in the New York Times, on NPR, The Economist, The Washington Post, Forbes, and other media outlets. And she's been provided to present at such prestigious universities as Stanford, Cornell, in Michigan, Texas, NYU, UCLA, and many other law schools, to groups of federal and state judges and attorneys across the country. Her articles have appeared in many top journals, including the University of Pennsylvania Law Review, USC Law Review, Georgetown Law Review, Texas Law Review, George Washington Law Review, Notre Dame Law Review, Boston University, and the Journal of Empirical Legal Studies. She's published a book, The Bail Book, a comprehensive look at bail in America's criminal justice system, with Cambridge University Press, has contributed greatly to the field of criminal law. She also has a textbook, Criminal Law, Case Studies and Controversies. Another one, co-authored the most popular criminal law study, Student Aid, Examples and Explanations in Criminal Law. She was voted Professor of the Year in 2013. She joined the faculty of the University of Utah after 3 years of teaching at BYU Law School. Served as chair of the AALS Criminal Justice Section Executive Committee in 2015 to 16. She has also chaired the ABA Pretrial Justice Task Force and as co-chair of the Committee on Crime Prevention, Pretrial Release, and Police Practices. And from 2014 to 18, she served as a member of the Utah Sentencing Commission. Before joining the Legal Academy, as I mentioned, she served as a Fulbright Senior Scholar researching pretrial detention in Malawi and lecturing in criminal law at the University of Malawi. While there, she worked as a justice advisor to the British Department for International Development, advised a coalition of international, getting tongue-tied this morning, international non-governmental organizations, including UNAIDS and UNDP, and represented criminal defendants in felony cases and in constitutional litigation. She worked as a litigator at Kirkland & Ellis in New York, receiving national press for her role in prison reform litigation. In law school, she served as the editor-in-chief of the BYU Law Review and clerked for Judge J.S. Bybee of the U.S. Court of Appeals for the Ninth Circuit. We are, as I said, pleased and excited to have her here talk to us about how we're not as bad as the public seems to think we are. And so with that, we'll turn it over to Professor Baughman.
Thank you so much. Can you hear me okay? It seems like pretty good. All right, I'm so excited to be here to talk to real live prosecutors about you guys, because you men and women, because I've been studying with prosecutors like Bob told you, for the last 5 years. And this is my first opportunity to actually present them to you. I have heard a few, random prosecutors from across the country who have read the study. They'll write in and say, I agree or I don't agree. So I'm very interested to hear what y'all think. Okay. Before we get into what we found in the survey that we did, this, what we call the field experiment, I actually have a copy of the study in front of all you all. So if everyone can actually just start taking it, I think that will be more interesting than me just going through the survey. So I'll just kind of slowly go through the slides of this if you don't have a pen. But so feel free to read if you don't have a pen in front of you. But let's just take the first 5 to 10 minutes taking the survey, because I think I promise you the discussion of the results will be way more interesting if you've had a chance to give your own answers to this. So let's do that. And those of you at home, please go ahead and take it too. I promise this will be way more interesting. It said, I think it said final prosecutor survey or something on the link. I saw it on the website. Looks like some people are done. Can we do maybe 1 or 2 more minutes? Would that work? We good? Do we need more time, or are we okay to... How far are we? What do we think? One more minute. Okay, thanks for letting me know. Good? Okay. All right. Are we all good to move on? Okay. So I wanted you to have a chance to look at that. This is, I'll tell you a little bit more about it as we go. So the reason we did this experiment with prosecutors, and I'll tell you more about how we set up the experiment, is because, as you all know, there's some disparities that we have in incarceration rates, right? So you look at our incarceration rates, quite a few more Black and Latino and Latina Americans are incarcerated than whites. And so lots of people have tried to study why is that, right? What, is this judges that might have some bias? Is there prosecutors or police? I mean, is there bias that's resulting in some of this disparity? Blacks also receive longer sentences for equivalent crimes. So a more recent study talked about that. If you look at kind of the shorter sentences versus longer, right, more Black individuals are getting longer sentences. Potential causes for this. What's happening here? I mean, all of these could be possible, right? So could be caused by educational, health, economic, cultural differences, choices, biases of decision makers is another possibility. Legislators, police, prosecutors, judges, juries, parole boards. I mean, all of these individuals could have bias that results in these results that we're seeing. And we're studying prosecutors, so this is what we're going to talk about today. So prosecutors, as you all know, have broad discretion. Whether to charge a case, what to charge, how many counts, what to demand in a plea bargain, what to recommend to a sentencing judge. And as you also know, these decisions are largely unreviewable. Because discretion is essential to the criminal justice process, we would demand exceptionally clear proof before we would infer that discretion has been abused. So a lot of discretion from the court to prosecutors. And this is what we as scholars call the black box. And I think actually it's not just scholars that might view prosecutors' decision-making as a black box. My sense is, in working with prosecutors the last 5 years on this, is that prosecutors also find it to be a black box as to other people, right? I don't think there's a lot of discussion amongst prosecutors on how necessarily other offices or even sometimes other prosecutors in a given office are charging a given case. And so you think of all of these different things that could go into a prosecutorial decision to charge. Could it be any of these things? That's what we're trying to figure out. And also the bigger issue is, aside from race and class, which we do study, we also wanted to see what factors are important to prosecutors. What are they looking for in deciding whether to charge a particular case? And as you saw, we gave you an example of a case that we thought highlighted some issues that might be interesting to look at. Okay. So black box, prior research, basically all of the research we saw when we were putting together this survey showed that there was a lot of racial bias against blacks particularly. So, greater odds of being charged, that blacks account for 58% of all federal cocaine arrests, for instance, and this is with police. Blacks arrested for shoplifting are less likely to have charges dismissed. So lots of them, and there's way more examples of that in the paper if you ever wanted to get into it. And as we know, and as Justice Simonis very articulately talked about implicit bias with gender, there's also a lot of accounts of implicit bias with race. And this is just one example of it. And, the question is, are prosecutors human? Do they also have implicit bias? And does that implicit bias lead to disparate charging decisions on similar cases? That's what we're trying to study. Okay. And so our research questions: can we control all the case factors that appropriately inform prosecutorial decisions, but may be associated with race? Can we untangle direct race effects from indirect race effects, i.e. class? So we tried to do that. Can we plot a practical solution to solve whatever implicit bias, race biases exist? And that's, the ultimate question. I mean, one thought and something we proposed that's actually, we wrote this paper in 2015. It's called Blinding as a Solution to Bias. We proposed that could prosecutors potentially blind themselves to any identifying factors that might lead to class and race. So the name of the defendant, the neighborhood they might have been from, any other kind of discussion of their body, build, any of that. And could this work as a way to cut implicit bias? And right now, the San Francisco DA's office, they did start this a few years ago, and they have had one paper talking about the results, but they actually also, with the blinding, were not able to see any real difference with prosecutors. So meaning those prosecutors that were blinded were not making decisions differently than those who were not. Okay. So what does a prosecutor need to know? And this is one question we went into this wondering, and I still would love your thoughts on this. Can the rest feasibly be removed, right? So, I mean, does a prosecutor need to know, the race? As you saw in your survey, there was a race and occupation. Well, could we remove those types of, that type of information? Particularly also neighborhoods that people are from, could those be removed? Okay, so our research design is we wanted real prosecutors nationwide We thought about, coming to a conference and giving it there like I'm doing today, but we thought it might be better just to try to do it as naturally as possible, sending it to them in their real environment. We did a vignette based on a single case, randomized between subject, experiment, and it's called a factorial design with control. That this stuff probably isn't as interesting to you, but what we did do is, in some of the surveys, the person was black, they were white. In some of the surveys, it was a fast food worker, and the others were an accountant. And the control group, the prosecutors were blind to all of those things. No race or class information at all. Okay. And so we thought, this is something that the National District Attorneys Association would surely be interested in finding out, right? We'll tell them we want to do an experiment on their members and test whether they're implicitly racist. They'll be glad to help. Nope. Not at all. They were not happy to help at all. And in fact, they would not let us even send an email out to see if anyone was interested as part of the association to help. So this is why this experiment took so many years. It took 3 years to get all this data because we had to get a geographically representative region. We had to find states with searchable bar directories. RAs had to manually find attorneys with relevant job titles and employers. It had to be state and local, obviously not federal, which is what we wanted. We started and identified 3,675 lawyers, prosecutors, which was going to be enough if we got a certain percentage back because we wanted it to be statistically significant. So we needed enough lawyers. So we emailed each prosecutor, asked them to participate for a $5 Amazon gift card. We did promise them results, which a lot of them were interested to get, and we gave them those. We hosted on Qualtrics. It was, blind purpose of study. We screened out extremely fast and short responses. We ended up with 441 responses that were, able to be coded. Okay, so as you know, we have the case vignette. You all saw it. We developed it with a prosecutor as well as tested it with a pilot office as well. Were any of you involved in any of this? Does this look familiar? Were any of you? Okay, you were. Were you in the pilot study? You did it, okay, in your office. Like you did it, the real one, not the pilot. Okay, wow, cool. Anyone else? Or just one? Cool, so this is probably especially interesting. You did it twice now, right? Okay, well, cool. So the manipulation, as you can see, sex, race, and then the accountant, as you can see, that's where we manipulated this in all the different surveys. Okay. All right. So as you saw, we asked you what you would do and also when's that decision. Okay. Survey results. This is what you've been waiting for. As a total group, 15% of prosecutors charged a felony. And as you saw, there's one felony on that list. Monetary penalty, 41% imposed a monetary penalty, average amount $242. Confinement, about 7% recommended confinement, average minimum days, 21.35 days. And this might be interesting to you, but this was our kind of jurisdiction characteristic. So average size of office, 31.96. And, they kind of ranged in size. You can see mostly smaller offices, which is really interesting. And this was because when we reached out to some of the heads of office, there were some in big cities where they just said, no, you're not allowed to allow any of our prosecutors to take this survey. So, which is surprising given what we've found. And you'll see, I mean, it was surprising that we got such pushback. But prosecutor characteristics. So average number of years, about 12. 22% were head prosecutors, about 46 average age. Way more men than women, 63 versus 34%. A lot more white than any of the other races. And this is just to show you, we did eliminate ones who did it too quickly, because you all know we've all taken surveys where we do it in 2 minutes and don't really read it just to be done with the survey. And so we eliminated those. Everyone had to have at least taken 10 minutes or we didn't count their results. Okay, and this is how we broke up the regions. We were in the mountain region, and I'll show you some stats on that too. Okay, variation, guidance, perspective. So kind of in thinking about this, we were interested in class and race, but something else that I'd noticed that is interesting is that when you look at national estimates of criminal filings and arrests, I think there might be something interesting there that we haven't really noticed or no one's really talking about. So if you look at, after 2006, overall arrests begin to decrease steadily until 2018, when they dropped to 10.3 million. So overall, between 2006 and 2018, there's a decrease of 28% in the number of arrests nationally. And so, we look at prosecutors, and police have cut arrests much more than if you look at prosecutor charging, than prosecutors have charged cases. So, prosecutors have cut arrests in a much smaller rate. And I'll show you this other chart that's a lot easier to read. So this one, looking at this period, says, look, in 2003, there's 1.1 filings per arrest that a police officer makes. But that rises to 1.73 in 2013, and then it kind of plateaus in 2018. This is the latest data that we had. So obviously FBI estimates are not perfect, and what national trends show, though, is that police have decreased arrests, but prosecutors haven't shown a commensurate decrease in filings. And one of the things that we're wondering is, could this be partly related to probation and other types of filings there? Is that what your question was? Yeah, go ahead.
I was just going to ask what your definition of arrests, is it actually taking somebody to jail, or does it also include issuing citations?
Not citations, arrests, taking to jail. Yeah. Any other questions? Okay. So this is something that's in the back of my mind as I read this, and I really do want your feedback on this. Is it the case that, putting race and class aside, as we will talk about those, but is it possible that prosecutors that are continuing to charge at potentially higher rates, even though arrest rates have dropped, crime rates have dropped, and what might be the cause of that if that's the case? And if, there's some obvious answers to you, I'd love to hear those too. Okay, so what did the national prosecutors do? I'd be curious to see what you all did. And if you're willing to leave your survey for me to read, I'd love to just kind of get a sample of this room, just because it'd be interesting to me. But here's the kind of number of charges. So as you notice, the most prosecutors charged two charges for this crime that you read about. Next was 3, and then 4. But interestingly, very few prosecutors charged nothing, right? 96% of prosecutors charged a crime for the scenario that you read. And all of you might be like, yeah, that's right. I think that's appropriate. But that's, something to think about. Felony charges per region. So there are some really interesting disparities by regions. So South Atlantic, obviously highest with the felony. Mountain, congratulations, were second highest in charging a felony for this crime at 22%. Quite a bit lower New England, as well as the West, South, Central. And I can show you that slide again if you're curious. So, we have East, South, Central. West, South, Central is Oklahoma, Texas, Arkansas, Louisiana. Okay, so moving along, we did that one. Did I? No, I don't know if I did that one. We did this one, right? Okay, so this one, confinement by region. West, South, Central, 0 confinement. Mountain region was kind of towards the middle of the pack there, as far as 31 days average for those suggesting confinement. Now remember, only 37% of the attorneys said that there should be confinement with this scenario. Okay, minimum days of confinement, some said 0, and then we ranged between that. And very interesting disparity as there were a few prosecutors that gave a year of time or more for this scenario. Monetary penalty by region. So West, South, Central, as you notice, they were very low on the confinement, but they gave a large monetary penalty, which might signify a trend in those jurisdictions to go there. Okay, minimum monetary penalty. Some were 0, and that range as well. One person or a few people gave up to $5,000. A few that were $1,000 penalty. And something I'm actually studying now is, as you saw, there was a class difference. So one of the people was a fast food worker, the other was an accountant. And what we're trying to do now is match up the prosecutors' responses. So, did they, and we found statistically nothing, but with a qualitative study, we're trying to figure out, okay, did people that say, for instance, I feel like this person is having bad luck financially, they don't have a lot of means, did they still stick them with a $1,000 penalty? Or did that impact what they ended up charging? So we're kind of matching, the survey results with what the person actually did to see, did they match up? Did you say that finances are a big issue and then not charge, or did you charge? So we're trying to figure all that out right now. Okay, odds of confinement, stats here, kind of, much higher in Middle Atlantic. New England was quite low as far as confinement, and East, South Central. Okay, so, and this was interesting. I don't know if this matches your views, but how line prosecutors make charging decisions. 72% said alone. And so really this does match up with how, scholars and others have talked about prosecutors as, do they have input? Do they have a boss that's telling them what to do? Typically they're making these decisions alone. That's what, the national prosecutor said. Are they using guidelines or not? We had some disparity there, but a lot of people said that they don't have to use guidelines. Some said they had some, others said we don't even have any. Okay. And for the kind of what happened with race and class? And Bob kind of stole my thunder with this one of we're not as bad as we might look, right? Because we found nothing. No discrimination from our survey, right? Doesn't mean that doesn't exist, but from this experiment, randomized experiment, best as we could try to trick you all into being racist. Just kidding, we weren't trying to. But no, we found nothing. We found nothing as far as charging, nothing as far as confinement, monetary penalty, felony. So there were no differences we noticed between a black accountant, a black fast food worker, a white accountant versus a white fast food worker. I don't know if that, any thoughts on that, but I can get all the questions at the end, I guess. Let's go through everything. So blinding. This was interesting. So we asked prosecutors, what information do you need to make this decision? And if you look at I kind of blow this up here, the victim's job, the suspect's race, the suspect's attorney, the rank of the cop, suspect's education, suspect's job, those are very little significance to prosecutors, right? So they don't need that information. And even, what they did care about, suspect's behavior, severity of the damage, use of weapons, severity of injuries. They don't really need to know, some of them did say they needed to know the name. Very few said they needed the race, right? This is one of the lowest. So I thought that was interesting to think, could there be room? Should there be more blinding? But, the response of that is, do we need blinding if we're not finding bias, right? This isn't a way to find bias. Okay. So this is kind of, covering my problems potentially with this survey, right? So clearly there's some strength to this. We did our best here with all the things that we had, but there's limitations, and I want to talk about those. So we tested one case. We did have a low response rate, right? Especially given that, some prosecutors banned their whole offices from taking it. There's also kind of potentially, variables that come into this and also the big one I want to point out is the possible back channel communication. We worried that if we gave this survey, you took it and then did you talk to your colleague down the hall and tell them about it and then you figured it out that it was about race or class or any discussion of that could have ruined our results. Conclusions. Okay. Race does not have a sizable effect in prosecutor charging. Class does not also have a sizable effect. Blinding seems to be minimally feasible, and that's just saying that, look, a lot of prosecutors are saying we don't need this information about race. We don't need the information about the victim's job and these types of things. Also interesting, there are wild variations on the same case, and prosecutors do have little guidance. And so those are things to discuss and think about. Pending questions, and I'm dying to hear what you all think. How did you charge the case versus others? Are prosecutors getting it right? Did you seeing this make you feel like, yeah, I think our prosecutors are getting it right? Do we care about prosecutor uniformity? that's one thing we noticed, is that there was not a lot of uniformity within office, within region, across the U.S. There was a lot of disparity there. And is there severity issues? Do some of you feel like there was some overly harsh prosecutors? And then other thoughts about the prosecutors and U.S. incarceration rate that I brought up earlier. So yes, dying to hear from you all. Let's kind of go around, and I'd love to hear your thoughts on anything, any aspect of it. Yeah.
The one thing I would have liked to have seen, if you were to replicate this,
Yeah.
the one part that to me was most overwhelming is his lack of criminal history, which to me kind of overrid almost any other decision. And I think you might have seen a similar result if you would have put 25 prior arrests. Everybody would have wanted to, incarcerate him. It would have been interesting if it was more in that middle spot of like a third arrest or fourth arrest. Would you have seen more?
So for you, because he had no criminal record, what did you do? What was your charge?
I wouldn't have asked for jail time, for example.
Yeah, but you would have charged something, you just wouldn't have asked for jail time?
Correct, like a misdemeanor charge with no jail sentence.
Okay.
That wouldn't have been my analysis for if it was his 25th arrest, and it would have been a lot harder to answer the question if it was a third arrest.
Okay.
And then I would wonder about that's where I guess the biases, I'd be more worried about how they would affect more of a discretionary choice.
Yeah. Curious, because, and this was kind of our thinking in doing this, is because it was his first arrest, part of our thinking would some prosecutors say, this is his first arrest, he's had a bad breakup, do I even charge anything? And most prosecutors agreed with you, and they said, no, I will still charge something. That's why we did the no previous history, because in my mind, I thought this guy definitely had a bad day and he did something dangerous, but it could kind of be almost anybody. It's not like he's got this, rap sheet that you have to deal with. I don't know. That was our thinking. But still, you all charged, most of you. Did anyone not charge any crimes here? One. I'd love to hear from you if you want to talk. But yeah, that's why we did it. I appreciate that. Yeah.
I just had an observation that, to me, it seems that the race question comes in more in relation to the sentencing and what's going to happen, because I think a lot of our job as prosecutors, is, not only the crime when it occurs, but it's prospectively, what is this person a risk to society? And I think a lot of times the problem is just the circumstances of not having a background in different cultures and minorities and different races. And I think that can have a big effect on disparity in circumstances, because, for instance, I have a case right now, I'm a defense attorney, but, I have a black kid who really doesn't have much of a criminal history, pretty serious crime, but I know that ultimately my biggest challenge at sentencing is going to be a judge is going to be looking at this person and really not have any background into his culture and the circumstances of his life, as opposed to maybe a white Caucasian LDS person. Yeah. And that's going to probably have a huge effect on what the circumstance of that case is going to be.
I love that. And did you take the survey? And I'm curious how your results were compared to the prosecutors. Are you the only defense attorney, or are there other defense attorneys here?
Well, I was a prosecutor for 20 years. Okay. So I've answered it based upon that. But
okay.
Yeah.
So what did you charge? Just curious.
Well, to me, I charged aggravated assault, and I was looking more towards the idea of this is a serious offense, but clearly something that, given his lack of criminal history, something that's rehabilitative. And so I was, 90 days jail, probation. That was my kind of idea.
Okay. All right. We'd love to hear more from others.
Talk loud while I get there. I'm getting in my steps.
When I looked at this, I had a concern that there's a definite difference between charging versus resolving the case. And I mean, as a prosecutor that handles these charging decisions, we went back and forth and we're like, okay, but did he actually brandish or did he, show the knife and stuff like that? And so a lot of
you're talking about with your group here talking about it?
Well, yes.
Yes.
Yeah. But then when it came down to how do we resolve the case as a prosecutor, and then we looked into all these other factors that we didn't think that was important for the charging decision, but for resolution as like monetary, time in jail. I mean, that made a big difference in how we would resolve the case, but not necessarily how we would charge the case.
And so is your thought then, because, I'll just give this charge and then there's going to be other decisions that people make as far as resources or that kind of thing to see if it goes through? Is that what you're talking about? Or what do you mean by resolving the case?
So, I mean, we looked at the police report, like a probable cause statement, and we're like, okay, what charges fit? And then we found, all right, these charges fit, so we would charge, I think what we came up with, ag assault, and I know, yeah, but there was like a ag assault and disorderly conduct. I mean, just because it fit the definition.
Right.
But then how we would resolve it? Ag assault with zero history? Absolutely not. He would not have a felony if we resolved the case. And
meaning by, how do you resolve it? Just by negotiating something, some sort of...
Yeah, I mean, we plead it down to a misdemeanor based on lack of criminal history, based on we'd probably find out more about his intent at the time.
Right.
But did it fit the definitions? And we were like, it was a close call.
And that's an interesting question, because prosecutors do have that discretion. I mean, you could say it fits the definition, I'm going to charge, but you could also say it fits the definition, I know it's going to end up being a misdemeanor anyway, do I charge anything at all?
I mean, and yes, that is absolutely correct. But then another further analysis would be, well, if you reduce it down to just, I'm just going to charge disorderly conduct, and then the defense attorney comes up like, hey, you got to give me something. You're only charging with disorderly conduct. Let's give me a deferred, disposition or something like that, which we wouldn't do in this type of cases. So, yeah.
I'm interested. I'm so glad you said that, because there were some prosecutors that filled out the survey that about maybe 9, I mean, not very many, but said specifically that, right? They said, it's more like a misdemeanor. It's not a serious case, but I'm going to use this as leverage in plea bargaining negotiation. And others would say, I would never do that because they, thought badly of that. But it's interesting that you point that out. I think a lot of people probably had that in mind, right? Yeah, very interesting. Others in this group that wanted to speak, or others?
Sorry, we're stopping here with Ryan first, Sandy.
I'll be quick. One of the things that affected me, or that I would have liked to have seen, was not just that the victim had input, but her feelings about it. That would have a drastic effect on what I charged, but probably even more so, like the previous comment, probably it does have a drastic effect on how I resolve the case.
Meaning that if they're willing to cooperate, you're more likely to move forward versus not. Is that what you're thinking?
No, meaning if she was affected and couldn't sleep in her own bedroom or something like that for some time, that would, the impact on the victim makes the charging or resolving decision on my part either way. If it didn't impact them very much, okay, we can get through with a disorderly. I still would have charged, but we could get through with the minor. I charged a disorderly conduct.
Disorderly. So you didn't do aggravated assault?
No.
No felony?
No.
Okay, that's interesting. Yeah, so a lot of the prosecutors did bring that up in their descriptions, is I need to talk to the victim, I need to figure out, what she says and what kind of thoughts she has. So I think you're not alone in that. Yeah. Thanks.
Sorry, I actually was just going to say something just like that as well. If the victim had a biased opinion in the study, I would have been interesting if that had affected a prosecutor's filing decision, whether they were like fervently opinionated as to one thing or another, because we get a lot of victims like that who clearly are maybe blowing the situation out of proportion because of one reason or another. So I would have been curious if she had been extremely affected and she was really aggressively wanted us to, if that would have changed people's opinion on what they were going to
I
file.
would love to see that. I'm curious if in your mind, did you charge something and what did you charge?
I did. I really liked the felony disorderly conduct and loitering, but then I would have done a plea in abeyance just because he didn't have any history. So that would have been like a no jail, maybe some counseling or something.
Yeah.
To try to help him out.
But it would still go on his record. You just didn't want to.
It wouldn't if he was successful.
If he had. Right.
That way it's kind of up to him to change his behavior.
We had a lot of deferred prosecution, suspended sentence. That's kind of similar to what you.
Since he didn't have any history, so.
Yeah, that's what and that's what we were wondering about that. Interesting.
So I thought if you're looking at racism, that you kind of focused on the wrong thing. You're looking at the charging up front and not the resolution. So when you go to like uniformity for prosecutors, it's pretty uniform how we screen a case and charge it. You look at what happened, the facts, you look at the elements of the different crimes, and you make a straightforward decision. What evidence do we have? That kind of stuff. And then it's when you get to the back end, the resolution, that you look at, the other factors and the facts, and then it becomes not so uniform. And it depends on a lot more of the discretion of the prosecutor. And so when you look at like jail time and things like that, and you see that discrepancy, that's where you see it. You see it on the back end.
Yeah.
In my mind though, I've always liked the fact that on the back end though, that there isn't necessarily a uniformity. We sometimes have these policies in our different offices and agencies, such as with DUI or something, if they have, an blood alcohol level above 0.1, we don't do an impaired, we're going to charge them with a DUI or something like that. But I think when you do that and take away some of the discretion, then you're not able to cater to some of the specific factors surrounding that specific case that maybe should be accounted for. And so I've always felt that in terms of prosecutors, the best thing you can do for criminal justice reform is just to get good people, good people that want to do the right thing, and then let them use that discretion and provide, the opportunities and experiences for them to grow on that. But anyway, so those are just my thoughts.
Yeah, I appreciate your thoughts. And I mean, we definitely didn't see the race and class bias. And that's interesting that you say that it does come out in sentencing, which also has, prosecutorial discretion in it. I'm curious what you think is to be, there was a disparity in the charging, right? So some prosecutors charged 2 crimes, some charged 1 crime, some charged 7. Does that bother anyone, or is that kind of like, well, we have discretion, we don't want to make a, kind of sentencing guideline sort of thing for prosecutors, and I wouldn't want anything like that. But is that sort of disparity something that was troubling, or is it something like, well, when you give prosecutors discretion, some will charge 7 charges, some will charge 3, and
I think you see that, but I think as you showed from the study that overall it's pretty uniform, and you'll have some outliers, and I think that's always the case when you've got humans, and then you can't take the discretion out of it. There's always going to be some level of discretion, but I think what the study has shown is that that's pretty uniform on the front end, on the screening process, that we're pretty good at doing what we're trained to do, to look at the potential charges, to look at the evidence, and then charge accordingly. So again, I still think it's the back end that we should be focused on, and that's where you're going to really see this disparity that you were thinking we might see in this study, but didn't quite see.
Yeah, we definitely thought we'd see it, and we didn't see it. I don't know if I agree with you about the uniformity nationwide. I think there was quite a bit of uniformity in geographic regions and as far as the number of charges, but anyway, we can just disagree on
So
that.
I have a question before we come here.
Yeah.
Have you done a study, or has there been a study between rural versus urban prosecutors? Because here in the state, the last couple of years, as a training committee, as governing, not the right word, the council at conferences, we talk about charging, and it seems like that there is, I don't want to say disparity, but a difference between what Wasatch Front prosecutors might charge or seek for a sentence versus what some of our more rural, smaller jurisdictions. Has there been any studies to look at the difference?
No, there's very few. Well, I think we might be the only nationwide study on prosecutors in the last, I don't even know how many years, that have even just looked at everyone. There's a great one in Louisiana. Ron Wright is a professor that did that one. And even in ours, we weren't able to get enough city prosecutors to compare. Most of our prosecutors were in areas where there's 100,000 or less individuals. So they're pretty rural, I would say, or, smaller towns. So we don't have that comparison. But yeah, I'm with you that there's going to be disparity. And if there is open jail space, that's going to make a difference. And that's why we thought this was interesting, because this is kind of a study of, what prosecutors want to do or maybe wish they could do, or maybe say that they wish they could do because they will plea it. But rather than, looking at the resources, because there's going to be different everywhere, right? Is there jail beds? Is there not? That kind of thing. But yeah.
Yeah, or just to piggyback off of that, I've practiced in a couple of different states, and to me, the variation between state to state practice is massive, and even within regions. So, having practiced in another state within the mountain region, and I mean, obviously, it makes sense that you'd need to group them in regions if you have a small sample size, but just as a thought about where those. And purely anecdotal observation about where those variations may be coming from, they may be locality based rather than from person to person, if that makes sense.
Yeah, for sure. No, different cities, different. And I'm curious, so kind of what did you charge? And then I'd be interested to see, because you've worked in different regions, have you had the same practice in all, or do you feel influenced by the office policy or our culture?
So I've been an appellate prosecutor in 3 different states. So asking me what I charge, I'll give you a 40-page brief about the common law. So to me, it strikes me as disorderly conduct, but I don't know that I'm an accurate bellwether for anybody in those 3 states as far as. But
it's interesting because you probably have seen charging, it's so
exactly. And so I see the disparities, and particularly, so my most recent move was from Arizona to Utah, and Utah, the sentences and charging is a lot less strict than I would have seen in Arizona.
Less strict.
And I think. For the better in that regard. I think Arizona is way too harsh in the way they charge a lot of things. But both of those would have fallen within the Western region, obviously. And like I said, it makes sense that you would want to group them together just so you can draw regional variations. But within that region, you may see huge differences in local culture. And for so many of us who may only practice in one state, that may be only the only culture you ever know. And that may be accounting for at least some of those differences that are not necessarily person to person, but state to state or region to region.
Interesting. Thank you. I love that perspective. Oh, you didn't say you said disorderly conduct. That's right. Oh, can we hear from our friend over here that didn't charge? Do you want to speak or no?
Not today.
Okay, got it. Anyone else have thoughts? Sorry, I didn't mean to pick on you, but I wanted to hear.
Thank you. I think it's really interesting that in all of the cases, or vast majority of them, prosecutors are charging less than what the legislature wants to see imposed. So.
Interesting. And I guess you see if the legislature prohibits something, they want prosecutors to go ahead and charge for that if they can.
What that's for, isn't it?
I mean, I guess it's possible. It's one way to do it. Other thoughts? Yeah. Yeah. Let's keep doing one question here, one question there, back and forth.
So I would reiterate a couple of things. I think that, so your study is suggesting that there's not a lot of bias affecting the charging decisions. And that kind of makes sense to me because I think we're not necessarily seeing a lot of those characteristics when we charge, even though it may say that the person is a fast food worker or accountant in the police report. I'm so hyper focused on the elements of a charge and finding the evidence for that. It makes sense to me that I may not be as affected at the charging stage. I do think it's more interesting to see if those play out through the plea agreement negotiation process, through the victim input process to where we get to the final sentencing. And then I think there's So first of all, thank you for doing this work because it's obviously very hard to do. I think it's also another reason why it might be difficult is because the different priorities of different communities, right? So in an inner city that has a lot of murders and gang violence, this case where somebody brandishes a knife in a not necessarily extremely aggressive manner, for that jurisdiction, they may not even charge, right? Or be more inclined to not charge because of the relatively lower end of severity. But in a rural community like mine, which is not under 100,000, it's under 10,000, right? This would be more on the higher end of seriousness of crime. And so it's probably something that we would be focusing a little bit more on. And then one question I had is when people are pointed out ahead of time, like you kind of alluded to this, that it would have ruined the study if somebody else knew that the study was about race.
Right.
So what did you do to help prevent that from happening so people didn't know they were being tested about race and class?
Yeah, good question. We can't do anything about it. That's why I wrote it as limitation because, I can't prevent you from talking to your friend about it. And what did you think of Michael Johnson? And, mine was black. Wait, mine was white, that kind of thing. And I mean, we are also aware that anytime if there's a, survey or something given to prosecutors and it implicates race that, we're all kind of in tune enough with the world today that we might see, okay, they might be testing me on race. Maybe some of you didn't think that, but we were thinking, at least some might be clued into that, and that could bias results because they're just saying, oh, they're testing me on race. And whereas if you're just meeting somebody, right, and they happen to be of a different race, then maybe you have more implicit bias, then you can't control it. But yeah, point well taken on the, the bias, if there is any, comes potentially later at sentencing or how you end up resolving it, how you plead it. And that was harder to test, right? I don't know how we could have done that, and I'm curious, so what did you end up charging because coming from a more rural place? Man one.
Yeah, murder, first degree murder. I would have liked to have seen the witness statements first. Can I make that?
Yeah.
I probably would have done the aggravated assault and then maybe a loitering charge. And
then would you have been more likely to follow it through, or you would still drop it with a plea?
Yeah, I think the plea agreement process would have been significant, partially because of no previous history. So I probably would have not resolved that case at a felony level, probably would have resolved it much lower than that. But I also would have taken a lot of victim input before making that decision.
Curious, and if others have thoughts on this in our last few minutes, is victim input in your experience typically more likely to push you to go to be more harsh or less harsh? Is that, I don't know what your experience is, I'm curious.
I see it both ways. I see victims so first of all, I see victims that don't want to have any, that are willing to testify, but don't want to have any involvement in the process if it's not needed. Right. And I have some victims that they want the person in prison for the rest, they want the maximum penalty, right? And then you have victims that are much more forgiving. They're like, I don't want this to ruin this person's life. Yeah. I want them to just be accountable for it, right?
And those do impact you as far as how you might negotiate.
Yeah, absolutely. I think I'm much more impacted by the victims that don't want a harsh penalty.
Mm-hmm. Interesting. Thank you. Appreciate it. And any other thoughts on that? I'd love to hear. We have a couple minutes on victims, how that impacts you, because a lot of prosecutors did say that. We just had to balance the survey being 10 minutes, and I thought it was already a lot to read, and I thought, we're giving them $5. That's really just nobody really is doing it for the $5. So we thought, well, would we get an even lower response rate if we had more statements? So that's why we didn't. But I agree with you. I think victim statements would have been really helpful.
I'm curious, was there one or two things that really surprised you as you were, going through the results?
I guess lots of things. The disparity was interesting to me, just seeing how, large some penalties were and small others. Some people, no big deal, 0, and others, this is a really big deal. And I guess, one of the things and you'll probably laugh at this because you're like, academics don't get it, but one of the themes in academia right now is that progressive prosecutors are becoming more of a thing, that prosecutors are nullifying cases, they're declining to charge cases, they're, responding to mass incarceration in a way of reducing their charges. And I'm just not seeing that. And this shows that that's not really happening, at least what we saw. And maybe, again, we did more rural than cities, and maybe it is happening in big cities. But that was one big revelation to me, is that, maybe prosecutors are doing like what you all do, which is, I looked at the facts, right? I looked at the statute and I just applied it. I'm not using my discretion to try to help incarceration rates or anything like that.
I'm curious if you would have seen more variation if the race was more obvious. A lot of us read reports like this all the time. I didn't even pick up on any of that because, like I said, I'm looking for relevant information.
Right.
So oftentimes, if we're looking at how we're going to prove identity, for example, how the person looked suddenly becomes relevant, and then I might pay attention to that.
Right. But typically with the police report, you never get a picture, right? Because that would have been a natural way to have a, race.
We do get booking photos sometimes, so you could do it that way, where included with it is a booking photo or something like that.
But would that have just screamed race to you in a way that would have biased you more, or?
Depends on how you did it. You might be able to, but you could have identity or something like that be an issue where someone's providing a description of the individual.
And there is a description, but it's kind of in passing. It's not done in a real.
So I read faster.
But you're kind of like, I figured that would happen too, and that's one of the challenges, limitations of the study is some people may not even notice the race, and I think that's fair. That's a fair point. Well, thank you all. I'm out of time. I really appreciate the opportunity to present this. If you do want to share your surveys, I'm happy to collect them and read them. I like this kind of stuff. So thanks for the opportunity, and hopefully you have all a great rest of your day.
Thank you, Professor Baughman. Thank you to those that participated. Good questions. Okay, we will take a break and be back at 11 o'clock.